Welcome back. It's Philip Bickle at Legal Tyranny. It's July 10th, 2021. We're continuing on my opening brief for my traffic infraction appeal. And we're still in the argument section. And actually, no, we just ended the argument section. Scratch that. We'll be starting on page 13 with the statute of limitations. And our table of contents shows, we're still in the argument section. Okay, so the statute of limitations, the issue for this court's determination is whether the state commenced prosecution before the statute of limitations expired. To make this determination, several questions must first be answered. When was the alleged crime committed? Number 2, when did the statute of limitations begin to run? What is the applicable statute of limitations? When did the applicable statute of limitations expire? When did the prosecution commence? When were the oral charges entered? These two are pretty much the same. I should have removed this actually. And lastly, was the delay unreasonable? So these questions right here explicitly come from a lawyer's appeal to, I don't know, I guess it was a court possibly in Florida. But I took what he wrote and I did some searches on continued related issues, basically statute of limitation appeals. And after reviewing in the state of Hawaii and a few other states that I got hits on, these are your core questions right here. So the court has to answer these, and depending on how they answer them, they may have to reverse. So in my situation, they should be reversing, but we'll see what they do. I mean, they're just so corrupt. The fact that they wouldn't take my interlocutory appeals because I was raising these issues of failing to be charged already, that's hiding from the issue. So I don't know. We'll see what happens here. Maybe they're waiting for COVID to take me out or something silly. Okay, moving on. So I'm going to answer these things for them because these are facts, and the prosecution would have to enter something to counter them, and they're not going to be able to. In fact, they've already admitted to several of these things. Okay, when was the alleged crime committed? The state has alleged that the offenses were committed on November 11, 2016. All right, the whole reason you want to say that they alleged it is because they're giving you an admission that's in your favor. So rely on what they say there. Now, let's see, when did the statute of limitations begin to run? The statute of limitations began running the following day, November 12th, 2016. What is the applicable statute of limitations? The SOL on the 2 petty misdemeanor counts and the 4 civil violations expired November 11, 2017. Some of you may not have practice in writing research papers or things of this nature, so just a real quick note. If you have like a lengthy phrase or something that should be well known, you want to spell it out the first time and then in parentheses put how you plan on abbreviating that. Try to stick with standard things too. You don't want to make things confusing. If the phrase isn't repeated frequently enough and it's not, or it is something that's pretty unique, then just go ahead and spell it out. That way they'll remember. What is the applicable statute of limitations? The SOL on the 2 petty misdemeanor counts and the 4 civil violations expired on November 11th, 2017. When did prosecution commence? At the time that the oral charges were entered in court, I had not had a warrant issued for my arrest, nor was I served with a summons for these charges. Hawaii Revised Statute 701-1085. That ties in with the statute of limitations for commencement of prosecution. So it states that in such a situation, a prosecution is commenced when the other process is issued, but provided that such warrant or process is executed without unreasonable delay. The state entered oral charges for this case on March 1st, 2019, also well past the statute of limitations, 475 days late. So, when I've been telling you guys that, like, they just absolutely ignored the statute of limitations and just kept pushing forward, this is what it is calculated out. They did not file charges against me until 475 days after the SOL had expired for violations that they alleged that I committed. And the thing is, they didn't ever provide any reasonable excuse. That's the next section. Was the delay unreasonable? At no time after the seizure by Officer Davies have I been absent from the state. Now remember, this ties in to the section earlier indicating when the period does not run. See, I'm knocking this out. They can't say that I was continuously absent from the state or that they couldn't find me. See, we were already communicating via mail too, directly to the post office. So they had my mailing address. They could communicate if they needed to. So we are making sure that they cannot try to use these excuses right here. These are the only excuses they could use for a delay. You got to think this through when you're making these, structuring your strategy and argument. It's all logical. It all has an order of operations. So at all times since the seizure, the state has had my address. At no point in time in the past 14 to 15 years have I been employed due to chronic health issues. I have mailed and received communications from District Court in Hilo, the Hilo Police Station, and the prosecutor's office in Hilo. I did not waive the statute of limitations. I made 9 appearances in court before the November 11, 2017 statute of limitations expired. The following prosecutors made appearances before the SOL had run: Evan Smith, Brianne Larios, R. Winston Albright. These are 3 lawyers. Okay, these people have gone to school. They've had education. From what I can tell looking into him, he was in Texas for about 5 years doing the same stuff, prosecuting, or standing there and letting the judge prosecute while he stands there. I believe she was from Washington State. I don't know. She's done like a bunch of anti-white work, and these lawyers are really bad about that. They create division as much as possible. There's very natural inclinations and things that make things run smoother within your own race. It's biological and genetic, and just mannerisms, patterns that come with races. They're legitimately there. Like I have a pretty strong background in behavioral science. Almost finished. My master's thesis was on motivation, and so these people, the lawyer class, really need to have people polarized. They need to have people concentrating on issues that drive division. And then they just each take up sides. And so in this case, this guy I don't know anything about, very little. I think he's been one of the people employed at that office the longest out of these two, or out of all three of them. But yeah, so these guys all made appearances. They had 1 year to enter oral charges. And I mean, you have to make them look as ridiculous as they really look. So one of the ways we do that is, in the period of 1 year, let's point out how many deputy prosecutors appeared on this. They had 3 out of that office separately appear. Okay, 3. That's 3 different people, 3 lawyer brains. 3 lawyer brains. And not one of those 3 thought to enter oral charges when this was the primary issue I kept raising, that I hadn't been charged, prosecution had not been initiated. Like, what's, like, I honestly don't understand why they didn't turn around and do what they were supposed to do. But I kind of think they don't know what they're doing. I think they're used to going in and letting the judges just run things. Like, you show up and the judge immediately starts doing their job. They ask you, do you have a driver's license? Do you have this? So they're prosecuting from the bench immediately. Now, what do I mean by that? They're asking you to divulge facts about the situation. That's an investigative query. That's a prosecutor's job. And many of these judges used to be prosecutors. So they've got that behavioral pattern down, and they, some of them, if they ever were to listen to this, which I doubt they would, but if they listened, they would have to step back and say, wait a minute, you're right. Like, if they're being honest, it's a different role they're supposed to play there. And, they're just used to being in that courtroom, many of them, and they just take the lead. All right, let's focus. So, not one of them entered oral charges or set hearings to do so. There are no reasonable grounds and facts that the prosecution can provide under HRS 701-1086 to explain the delay in the presentation of oral charges. So I'm calling them out. They had one thing that would, give them a chance to move forward after the statute of limitations, but it had to be a reasonable excuse. And I show that, there's absolutely nothing reasonable. So at trial, prosecutor Linnea Downs failed to provide any excuse for entering oral charges 475 days after the statute of limitations had expired. Instead, the prosecutor allowed Judge Freitas to make a perverted interpretation of how the statute of limitations worked, and the trial went on. Okay, let's see where we're at. Conclusion. Let's knock this out. For the arguments made above, I conclude with the following thoughts. The state prosecutors failed to charge me within the statute of limitations for the alleged offenses. I am entitled to the right to due process at all times. The trial court officers, be they clerks, judges, or prosecutors, have all repeatedly engaged in acts depriving me of this right, and some of them have acted in knowing collusion to do so, as the official video transcripts demonstrate. Defendant-Appellant respectfully request this court: 1. Order that the April 12, 2019 judgments in favor of the state entered by Judge Harry Freitas of the District Court of the Third Circuit be reversed. Okay, that's a digital signature right there for digital filings. And so this is the electronic certificate of service. Again, this is their system here in Hawaii. Your state may have one, and you have to consider whether or not it's worth the cost-benefit ratio of signing up to do electronic filings. You can file right up to the, like, practically midnight on a day something's due. So if you like proofreading, you can take advantage of that. But you won't be able to take advantage of their not keeping up with things. They're allowing computers to just auto file stuff for them if you stick to US mail. Okay, so that's it for this. It was short. If you have a really solid point to appeal, something like this that's just, belligerent, you can go forward on just that. If you don't have a lot of time, or maybe you got arthritis and typing stuff up is a pain. So if you like the video, if it was useful, if you think other people would benefit from it, give it a thumbs up. If you're not subscribed, consider subscribing. And if you are subscribed, hit the notifications button to get updates when I post this. And as always, anytime you can cut and paste videos that you think other people would benefit from, please do it. Because I'm one guy. I can't spread this stuff easily. And all it costs you is maybe 5 minutes of your time if you do it to send it out to a few people. All right, until next time.